What's going on? Peace and love. It's Clifford Jefferson L. Bay, member of the Church of England, descendants from the Royal House of Plantagenet, known as Godfrey, which is an Old English term for the modern term Jefferson, who was Viscount of Anjou. If you know your history, it goes back into the time of the Kingdom of Jerusalem, House of Plantagenet, dealing with the Kingdom of France. As I get into my lesson, and throughout my lesson, I'm going to drop some jewels and to show you exactly why we're going through what we're going through in this time of day, dealing with what we call the coronavirus. If you break down the word coronavirus, the word corona means crown. And the word virus is a term that has many different meanings. But in this particular lesson, it's in reference to input. The coronavirus is about the incorrect information about who is the king. All right, because the United States is under the jurisdiction of the Kingdom of England. Pardon yourself, is under the jurisdiction of what we call, pardon yourself, my screen just went black. Under the jurisdiction of what we call the United Kingdom, which is under Queen Elizabeth II. All right, she got her authority from King George VI, which was her father. All right, so now her father was King George VI, but she was the daughter of King George VI. She got authority from the House of Stuart with Queen Anne back in 1714, if you know your history. But this particular purpose or lesson is for us to understand that the reason why we're in the condition is because this coronavirus, this misinformation or input or compute about who the kings here over in what we call here North America, okay? And who are the people who put us in the condition as subject to the United Kingdom under the authority of Queen Elizabeth II under what we call the Roman house, all right, the House of Hanover, which would be called the Kingdom of Great Britain. All right, now Queen Anne was the Queen of Great Britain until 1714, until it transferred to the House of Hanover, which became the institution what we call Rome. Okay, so now all those who listen to this lesson, I advise you to look at the format of this particular affidavit and follow them accordingly. Use the same terminology, but you as the particular party that's involved. As you see me as the plaintiff, Clifford Jefferson, as you can see, let me go up a little further. You see here, plaintiff Clifford Jefferson, defendants, probate court, and Department of Health and Biostatistics. They're being sued in Superior Court of New Jersey, Law Division of Middlesex County, docket number MID, Law Division 295/20, civil action. So now if you go to the top of the affidavit, you see the flag of Plantagenet or Jersey. This was the particular flag governing this particular territory prior to John Carteret and George Berkeley getting the charter from Duke of York. You see the fleur-de-lis, which is our holy symbol, and you see the flag of the Anglo-Saxon Berbers created in 1970 that's ruling president. But the story of the Anglo-Saxon Berbers goes back way before this flag. And by the way, the year 1970 is the year I was born. Okay, as you can see, it says Clifford Jefferson L. Bay, member of the Church of England, descendants from the Royal House of Plantagenet, descendant of Godfrey Jefferson, Viscount of Anjou. Know your history, brothers and sisters. You got a surname for a reason. This authority lies in the authority of the Crown of Plantagenet of the Kingdom of England that ruled from 927. This is at the time of King Alfred the Great's son Ashton, all right, till the present, to this day and time, it's still ruling. You see point 1 of the affidavit in this, which we call a public interest lawsuit. You see that New Jersey Provincial Council was the upper house of the New Jersey legislature under the colonial rule until it was replaced by New Jersey Legislative Council under the New Jersey Constitution of 1776 under a state church. Now, a lot of us don't understand what the Provincial Council was. They was what we call the council for that ruled what we call New Jersey Provincial Congress. This was the rule of what we call the Kingdom of England, okay? This was the ones who gave authority to the puppeteers such as John Carteret and George Berkeley, which were your so-called modern-day governors or freeholders and so on and so forth. All right. But for the sake of time, I'm gonna go on and continue on with the explanation of this lawsuit that each and every one of us should be filing in lieu of slavery created by the Department of Health Biostatistics. This also involves the United States Census Bureau as well as the Social Security Administration. Okay. This jurisdiction which we're filing this lawsuit is Middlesex County within New Jersey. Prior to it would be called county, they were called shires. Okay? They were definitely called shires. Look the term up. It's ancient. All right? And what we call New Jersey. Before it was called New Jersey, it was called Jersey. Jersey is the flag you see that I just showed you back up here. The flag of Jersey, the flag of Plantagenet. That's it right there to your left. Okay. Now we want to break down this. First of all, this says this affidavit of reply supported by a motion of denying the defendant's motion to dismiss complaint with prejudice, because as we know that when you're filing a civil lawsuit against these so-called corrupt officials, they always move with a 12B6, a motion to dismiss, without answering the discovery request in lieu of interrogatory questions. Well, I'm going to show you today that this motion to dismiss will not stand in lieu of their admittance to what they're doing in this present day, which we call modern day slavery. This was due to what we call the institution of the Indian Citizen Act of 1924, which is done away with the notice of registration of 1924, okay, which we're going to get into. All right, this is the facts of the procedural history. We say one, it says defendant was served with summons to complaint that was filed with the Superior Court on February 5th, 2020. So let you know this is the present case that was filed. 2, defendants were asked 14 interrogatory listed on page 3 and 4 with supported exhibits of birth record, which is your birth certificate or certificate of live birth. The Social Security card was also linked to your certificate of live birth, which is also filed with the Department of Register. This was done in lieu of what they call the notice of registration that's sent out by who? The Department of Census. All right, to note the population or who are here in North America or call themselves as American citizens. Also, as filed with this particular complaint was a showing of my Jefferson family crest that goes back to the Middle Ages of the Anglo-Saxons. That was filed with the original complaint that was then received on February 10th, 2020. And point 3, the defendants were asked additional 19 interrogatory questions concerning the birth record and the United States Census Bureau, as well as concerning the Social Security Administration in reference to the Social Security card on page 1, page 4, and page 5, which exhibits that they received by way of certified mail on March 12, 2020. Exhibits A, and those of registration of birth form of 1924 from the United States Census Bureau that was actually created on request of the Department of Health and Biostatistics. They actually informed the United States Census Bureau to do this, as well as Exhibit C, application for order of vital record for getting a copy of a non-genealogical record, as well as the another exhibit, the Berger family crest, which is on page 5. Okay, excuse me. This is the legal argument, my brothers and sisters. Defendants moved this court to grant a dismissal with prejudice pursuant to a procedural rule such as 4:6-2, Section E, supported by a mirage of case law that's asked of any evidence to support a motion to dismiss with prejudice in such a case of this magnitude. Point 5. Defendants stated on page 3 or 4 of their motion to dismiss in response to my complaint that was filed that the court must view the allegations with great liberality, which is a quality of spending generously and freely, or of being open to new ideas or different people and lifestyles. For example, I'm going to give you an example. When you are accepting of a people of all races, including mine, the plaintiff, as being of English lineal descent and of the English ethnicity. Okay, and point 6, in lieu of my legal argument, defendants believe that torts against an agency is protected by New Jersey Tort Acts, New Jersey Statute annotated 59:1 L sequence, which Supreme Court ruling in case law are contrary to the presumption of belief. which I'm going to show you. All right? So only thing you got to do is copy this affidavit word for word, because based on what I'm giving you, I might not be around for long, which is all good. You know why? Because this is why they're shutting down. We're about to be awakened to receive our kingdom back, okay? We're about to receive it through this information, knowledge that involves the Department of Health and vital statistics. These are the main two people involved in what we call the coronavirus, right? You see all around the world, everything is shutting down. Why? Because the true knowledge of how the so-called founding fathers or the freeholders or proprietors existed to this day by ignorance, or what we call a building ignorance of us buying into a social contract which we have no little say of the matter. We're going to prove it by way of this birth certificate. Okay? Point 7. I'm going to show you how the United States Census Bureau has a part to play in lieu of the Register of Birth filed with the Register of Vital Statistics, in lieu of the counting of the population, which is the reason why we need census to account for all the ethnicity groups here in North America, so you can receive welfare, assistance, housing, food, clothing, shelter, protection from laws in lieu of your social right or your civil right or social standings, okay? But before we get to that, we want to go back up here. Origin of the word state. You see that? It's a state is a Middle English as a noun, partly shortening of English term estate, spelled E-S-T-A-T-E. Now we all know that the word or term estate deals with property. This is the English term, but the Middle English term is spelled S-T-A-T-E. Brothers and sisters, this is a 12th century word that comes by way of the Norman conquest of England. All right? Okay, in Latin, the status, manner, or standing shows or refers to a condition or status. The current verb tense dates from the mid-17th century. Okay, so this is why your so-called founding fathers don't use the middle term estate. They use the 12th century term state, which means that they're using the term that came from Norman French. Okay, this is why you had the French and Indian and British War. Okay, this is why you had this war, because the French, Norman. All right, we're going to get into that as we go through this lesson, but I'm going to show you the basis of this complaint in lieu of the history that's been diluted with the truth, and show you that in lieu of this complaint is already filed with the courts against the Department of Health and Vital Statistics and any other party that's bound to this contract by way of agreement, by way of this fraud that's being done to our people. Okay, so all you need to do is, you know, as you build these lessons, give me a call, shoot me an email, hit me up on Facebook, hit me up on YouTube, and get down as a defendant, as a plaintiff in this complaint, relative to the lineal descendants of the true people here that failed to be recorded in lieu of the request in a law created by the Department of Census in lieu of recording the birth here as recorded citizens. Not just American citizens, but any ethnicity here. But most people self-identify their citizenship by American and waiving their ethnicity of their culture, lineal descent, status in life. This is what they do. Okay, so this is why this lawsuit is filed, and this is the reason why this complaint is filed. And these are the facts and procedural history. These are the legal arguments in regards to this complaint. As we go back down to grounds. Point 7. Okay. Brothers and sisters, y'all see that. Grounds for denial of defendant's motion for dismiss with prejudice. Because as I stated before, they always move for a motion to dismiss. This is the reason why. That it should be dismissed in lieu of the law. 6.7. The notification of birth registration form was issued by the United States Census Bureau during the first half of the 20th century, which is not a birth certificate. The United States Census Bureau designed this form in 1924 at the request of various state vital statistics offices to promote the accurate registration of birth in what we call the United States. Do you understand what this is saying to you, brothers and sisters? A notice of birth registration is not a birth certificate. They specify that. They reached out to the United States Census Bureau, which is in Jeffersonville, Indiana, which is where the Native Americans are from. All right? Bunch of villages and tribes that lived in Mississippi culture, that encompasses all the way from the Ohio River all the way down to Louisiana. Okay? All this was our land. All right? But they started the Census Bureau in lieu of notification of registers of birth that was done on behalf of Biostatistics, which is the Department of Health. Every county got one to promote the accurate registration of birth in the United States. Now remember what we said before the United States. Because the states were independent before they became the United States. Am I right? This came to what they call the Quentin Party Deed that was given by the Duke of York to John Carteret and George Berkeley. We're going to get into that. All right? But it says here, at the request of Biostatistics Office to promote the accurate registration of birth in the United States. It says the notification was completed and sent to the parents, okay, of newborns when the state office of Biostatistics received information on the birth. That means your mother and father going down there and showing that a birth has taken place. It said, and receive information on the birth, ethnicity, and religion, okay? Now, we don't see none of that on the birth certificate, do we? No. It's supposed to be there, though. It said, within this notice, it said the parents were asked to correct them if any of the information was wrong, and then return this form back to the state records so it can be corrected accordingly. See application order and vital record, copies of non-genealogical birth certificate, Exhibit D, which I attached in this particular lawsuit, okay? Now, the reason why I stated point 7, why, is because of this. The 2010 census status in regards to race and ethnicity in the United States. Do you guys see that? I hope y'all see that. Okay. The predominant religion here, or ethnicity here, or language here, based off its founding, was English. We can all agree to that. Of English ethnicity, not English American. None of that. Part self. Let me turn the camera back. Based off English. Alright? It says here, 2010, it's done every 10 years. The United States Census answers to what they call the Department of Commerce and the Department of Labor, which was, prior to that, was under the authority of the Department of Interior, and prior to that, it was under the Department of what they call Marshals, all right, which answers directly to who? The President, all right? It's in every 10 years to count the population in lieu of them counting the seats in lieu of election. Now, you know this, the Census Bureau is still going through because they want to make sure that they fill those seats, all right? It said, but if you look at the census, as it states here, main article, race, ethnicity in the United States, 2010 United States Census Bureau. The first one you see up here, self-identified race, is white alone. You see that? It says 72.4%. Then you got black or African Americans, 12.6%. Then you got Asian, 4.8%. You got American Indians and Alaska Natives, 0.9%. Native Hawaiians and other Pacific Islanders, 0.9%. Then 2 or more other races. Now they only got 6 races on the Census Bureau. Hispanic and Latino America make the 6th one. It says here, the United States of America is a diverse country of racially and ethnically. Pardon myself for the misspeech. I suffer from a speech impediment, but it's all good. 6 races are officially recognized by the United States Census Bureau for statistical purposes. There is no English ethnicity listed. You see this? There is no English ethnicity listed. How can that be when English is the country founded is based off the English people? It's based off that. So where did the English people go? We got English last names, don't we? We speak English, don't we? English people were based off Anglo-Saxon descendants, right? I'm going to prove to you that that's us. And the people who identify themselves as white are actually British subjects who are Protestants who are of what we call the Teutonic or German descendants. We're going to prove this. Let's get further up. Point 8. You see that? It says white Americans are a racial or ethnic group of Americans who identify as and are perceived to be white people. The term is usually used to refer to those of European descent, though it's at times, pardon yourself, though it's also used to refer to Americans of North African and Middle English descent, for example, in the United States Census definition. So it just said, according to the census definition, white Americans are a racial ethnic group of Americans who identify as white people who are of European descent. Point 8. Look it up. Here's another fact. Point 9. White Americans, including white Hispanics, constitute the historical and current majority of the people living in the United States, with 72% of the population identifying as white in the 2010 United States Census. European Americans are the largest ethnic group of white Americans and constitute the historical majority population of the United States since the nation's founding. You hear that? Historically represents the total population since the nation's founding. The founding was only founded in what? Or recognized as independently by way of the Treaty of Paris in 1783. And Thomas Jefferson knew that was false. Why? Because they lied. We're going to prove to that by the end of this lesson. The truth is indigenous people here are called Native and not Native American. Because according to that chart we just seen, there you have it here, you don't see English natives. You don't see the English native. You see black, and they only 12%. So if they're the indigenous people here, why are we only make up 12.6%? Shouldn't that be well over 2 times, 3 times that of the white alone? So if that means we only 12% on this chart identified as black or African American, and they deprive us of our ethnicity as English or Anglo-Saxon or English national, then why you think we don't get the assistance that we need? Because blacks were subjects. African Americans were subjects of the British colonists who enslaved them. America is found off slavery. You don't believe me? Let's see what Wikipedia has to say about that. Point 10. American ancestry refers to people brought to America as slaves in the United States who self-identify their ancestral origin or descendant as American, rather than the more common officially recognized racial and ethnic groups that make up the bulk of American people. You hear that? 11. European American ancestry refers to people in the United States who self-identify their ancestral origin or descendant as American, rather than the more common officially recognized racial and ethnic groups that make up the bulk of American people. The same as English American. Okay? The same as what we just said as American ancestry. Point 12. According to the 2000 U.S. Census, there are increasing numbers of United States citizens identifying simply as American on the questions of ancestry. I wonder why that's so. Because they don't have a box to check anything else other than what they gave you. All right? That's why. It's called novation and assignment. Look that up for a definition. Point 13. This is the basis of my lawsuit, brothers and sisters. Who are we in this so-called land called America? Where are our rights in this so-called land called America for American people? What was it prior to this land be called America, which is identified, self-identified now as American people, prior to the multitude of ethnicities around the world? 14. English, Anglo-Saxon, Berbers, this is point 13. The continents of America meeting means indigenous or American Indian descendants from the inhabitants of the original British 13 colonies, called colonial American ancestry, known as white Anglo-Saxon Protestants, also known as the Know Nothing American Party, or Old Stock Americans, primarily of English Protestants who saw the point 14, the English Anglo-Saxon brothers as a threat to traditionally American Republican values because they were loyal to who? The papacy. Rome. Okay? Now all this was done in 1924 through what they call the cultural assimilation of Native Americans done by force. Alright? Have you ever heard of that? This is when you get into Little Turtle, which was of the Miami, Ohio Native American tribes, who band with the so-called British, Thomas Jefferson, Henry William Harrison, John Adams, all these people, George Washington, Francis Stuyvesant, all these people were profiteers who overthrew the natives here, who now identify them as subject to them classified as Indian through what they call the Indian Land Corporation. You brothers and sisters got to know about this. Now, in 1924, notice of registration was given to the parents in lieu of their ethnicity. But there was no longer need for this notice of registration. Why? Part and so. Let's get back on job. There was no need for this notice of registration. Why? Because they felt as though the United States Department of Census and Vice Statistics were keeping good records. It stopped in 1940. Now, this is due what they call the Indian Citizen Act of 1924. This was due to make Indian citizenship what we call America by culturally assimilating them into the American way of life. Okay? It says here, through cultural assimilation or forced assimilation of Native Indians, now make them Moors of the state through the birth record. This is due what we call the progressive era. Here's case law off the butt to substantiate that. Okay? Now here's some case law to support and justification of this lawsuit I'm filing on behalf of the English National, all right? That some of you people think I'm crazy. But if you don't get down with this lawsuit, and if I prevail, you will not be counted amongst the people. I assure you that. All right? I'm here trying to dissolve the state that we're in so we can claim our estate, i.e. our own property, our own lives, under our own laws. All right? But because y'all want to be socially contracted as American citizens by way of the birth certificate and social security card, you agree to waive some of your natural substantial rights for the rights of your benefits created by law. But as you see, through this so-called coronavirus, those rights have now been suspended. All right? So if you don't have if you're saying you're not a citizen of America, then where your rights come from? Because America is now functions, the government now functions, then who precedes it? Who they got to go to for questions? Who they have to go to for questions? Because the president is nothing but a profiteer. He don't run the government. He does not. The governor is the complete authority of each and every other state. And that authority comes from what? The king. Under the provisional Congress, which gave authority for the Constitution of 1776, which the state and its agencies and the county by way of their freeholders, which are obligated. I'm about to show you that. All right? It says here, decision on sovereignty, citizenship, slavery, and debt and taxes. Debt is a tax. It says Calvin case of 1608, also known as the case of the Postani, was a 1608 English legal decision establishing that a child born in Scotland after union of the crowns under James VI and the First in 1603. By the way, this is the one who wrote your Bible, brothers and sisters. Was considered under the common law to be an English subject and entitled to the benefits of English law. Did you hear that? Now, we so-called speak English, but we don't practice English law. You're subject to Roman law. Since the Calvin case was eventually adopted by the courts in the United States, and the case played an important role in shaping American rule of birthright citizenship, be it just so. law of the soil, or citizenship by virtue of birth within the territories of the sovereign state. Okay? The Court of King's Bench ruled in Calvin's favor, finding that he was not an alien and did have the right to hold land east in England. However, the case has also been cited as providing legal justification for restrictions of legal rights to Native Americans following their widespread conquest or confinement and reservations by colonial forces of North America through that Cultural Assimilation Act of Citizenship, through the Citizen Act of what? 1924. Okay? So you just waived the rights. You don't act like I don't know what I'm talking about, okay? Point 17. United States Supreme Court case Taylor versus Mays was a decision respecting the authority of Berber tribe or tribes or people identified as Indians government. This case decided that the individual rights protections, specifically the Fifth Amendment, which limited federal and later state governments, do not apply to tribal government. Did you hear that? So if you're saying that an American citizen, you belong to a tribe of natives, choose one. Because you better not say Indian. You better not say Indian, because you're subject to them under the Indian Land Company. All right? Look, Little Turtle up. Little Turtle in the Treaty of, Vincennes in 1803 and 1804. Look it up. He was giving black so-called people as slaves from Thomas Jefferson and the rest of the presidents for assisting them. Okay? He was giving slaves to natives. Here's another person, Elizabeth Keys. You see that? Point 20. Elizabeth Key Greenstead, or Greenstead versus Humphrey, 1630 through January 20, 1665, was one of the first black question mark. She wasn't black. I'm about to show you why, in pursuant to her case. A person of black people of North America colonies to sue for freedom from slavery and prevail. Elizabeth Key won her freedom and that of her infant son, John Greenstead, on July 21, 1656, in the colony of Virginia. Key based her suit on the fact that her father was an Englishman and that she was a baptized Christian. Based off these two factors, her English attorney and common law husband, William Greenstead, argued successfully that she should be freed. The lawsuit was one of the earliest freedom suits by a person of Negro ancestry in an English colony. Did you hear that? Okay. This is why? Because of this what? Sescuque via, Latin for he was alive. She was no longer a slave. She was considered counted amongst the living. The population. You see by the Department of United States Census Bureau, we're dead. We're not even on the census survey of people who are alive. Sesquiquae Act of 1540, revised in 1666 by Charles II. Okay, was the Act of Parliament of England. Did you see that? The 1823 case of Society of Propagation of Gospel versus Town of New Haven looked at the issue of lands granted to the English corporate body society, which had a religious purpose. The lands have been granted by George III of England and New Hampshire, which is now what we call modern-day Piscataway, brothers and sisters. Yes, sir. In 1761. It was held in the corporation by a form of a, what? Sesquiquae. On October 30, 1794, the state of Vermont passed a statute whereby the land of society would be appointed by the state, not the United States, not the president, the state, i.e. who runs the state, the governor. All right, the Supreme Court was divided in its opinion. It ruled that the property of English corporations at the time of the Revolution were protected by the Treaty of Peace of 1783. There you go, back to that Treaty of Paris. Treaty of Paris. Treaty of Versailles, 1783, there could be no confiscation of such corporate holdings or lands because of the treaty. This is where your virginity comes back, brothers and sisters. Look up that Treaty of Paris, 1783. They lied. Why? Because in the ratification was January 14, 1784, which Thomas Jefferson said that there was enough delegates to sign this treaty, and to lie about it will be a dishonor to the British Crown, which they did. Cats out the bag. Cats out the bag. Look at the Treaty of Paris. You see only 6 delegates, between 3 or 4 delegates sitting there with half of the patent incomplete. Why? Because there wasn't enough delegates to substantiate the treaty by way of the delegations that was appointed pursuant to the treaty created by King George III, which was still getting its dirty who by King George I, which was passed by Queen Anne in 1714. How much do y'all know this history? I'm tired of playing with y'all. I'm tired of playing with y'all. If this go through, you will not be counted amongst the righteous. I'm telling you, because it all comes through my house. 22. Ecclesiastical court of Christian or spirituality was transferred to the court of probate of Circuit Court by way of the Probate Act of 1857. This is why I'm suing the probate court, because they're not doing their job in lieu of dissolving this social contract created by the state, i.e. violence protectors and health department. Why? Because they want to remain in slavery. So therefore, they transferred the power of the probate and circuit over to the Superior Court. I don't see nowhere in this Probate Act of 1857 that ecclesiastical court was transferred to the Superior Court. It says probate court. That's where you're supposed to go to. So in conclusion of this particular lawsuit, on the grounds why judgment should be rendered, the plaintiff moves this court upon steps of liberality laws of dependency pursuant to ecclesiastical laws, administrative law of life and ethics, food and drugs, knowledge, obligation, agreement, property, succession, money, trade, language, civilization, entities, religion, sacred texts, treaties, rights, and customs, sacred offices, divine sacraments, and time, places. This is under Canon Law Article 2, Canon Law 1241, if I'm not mistaken. Look it up. All right? Why is this so? Why is this so? In all American jurisdictions, one second. In all American jurisdictions, the grantee from one whose lands is advisedly held is still precluded from maintaining an action in his own name to oust the adverse possessor. A conveyance of land held adversely to the grantor is temporary and void. The title to the land remains in the grantor, i.e. Anglo-Saxon tribe, and the grantee cannot maintain an action to breach of the covenant and the conveyance. The fact that the transaction was fair and bona fide does not change the rule. It has been said that the common law doctrine is obsolete and not being suitable to conditions and circumstances of the people of this country that we call what? America. Why? Because they're operating under what we call fraud. Governance note: Wikipedia initial anarchy integrated democratic and hierarchical elements over time, meaning that they're not subject to anyone's copyright. It's free. American ancestry is derived from English Wikipedia, the free encyclopedia. And there's also what we call the Old English Anglo-Saxon Wikipedia. And this is my lineal descent, my brothers and sisters. Do you see this? Do you see that? Do you see that? One second. You see here? There's the Jefferson, my family crest, and the Berber family crest to my right. Okay? Lineal descent of plaintiff's estate. In America, it's called state, S-T-A-T-E, i.e. standing, at law. Okay, Jefferson. Excuse me. All those who think I'm crazy. Jefferson's surname was first found in Herefordshire, where they held their seats from very ancient times. The surname comes from the son of Godfrey, or forename meaning peaceful place. The surname is not that common in Europe. Jefferson is more common in Anglo-Saxon Berber tribes in England, America, and Africa, with recent discoveries showing that the main genetics of the people with this name has proven to have a Y chromosome belonging to the haplogroup known as K2. Genetics study shows that the Y haplogroup is extremely rare in Europe and is more likely to have come from the Northwest Africa or Middle East of Eastern coast of Africa. Did you hear that? Did you hear that? All right? So here's my proof. I don't know what proof y'all got. The history of the name Berber, you see that? Begins with the Anglo-Saxon tribes of Britain. Did you see that? I just showed you the family crest. The history of the Berber. Now, how did they get from Africa all the way to England? Because, you know, this particular territory known as America was under English possession. All right? Prior to the British colonies coming here. So these were the indigenous natives here, which were not called Indians. They were Anglo-Saxon tribes. Go back to what we call Clark County, Knox County, Randolph County, Wayne County, what's another county? They got cities called Jefferson City, Jeffersonville City, Knoxville City, Vanessa City, these cities where the Native American, native tribes lived. You know, they had mounds there. One mound was called Angel Mound, spelled Angel. I look up the family crest of Angel. It goes back to the Anglo-Saxon tribes. So here's your proof to substantiate the claim for slavery practiced by who? Social Security Administrator, Department of Health and Biostatistics, and United States Bureau Department of Census. All right, there's defendants here. You already did your homework for you. All right, here's Calvin case by the way of the King's Bench. All right, it's right there for you. All right, here's Social Security Administrator to support Exhibit D, notification of birth registration that they stopped in 1940. Department of Health and Registration issued it asked the Department of Census to create a form for notification of birth regard to one's birth, religion, ethnicity, and so on and so forth. When we look on your birth certificate, does it show any genealogy or any genealogy or descent? Does it? No. It just shows you that you was registered with the state agency. But they're supposed to be giving out notification of birth that the parents are supposed to be filling out in regards to ethnicity. The only person they got is the mother's maiden name and the father's name that's signed. That's not even signed. No signature. That's an invalid contract. Invalid. It said many birth registrars send a notification to a birth registration when a birth has been recorded. The purpose of this form, now remember, this is dealing with the United Census Bureau in regard to the biostatistics that's on the Social Security Administrative website. Social Security. Hold on. On the Social Security website. The purpose of the form is to notify the parents of the information contained on the birth record so that any necessary changes can be made on the record so that when the time of census comes, you can be recorded of regards to your ethnicity so that measures can be taken in regards to protecting your civil or social status, i.e. estate. But we have no estate. Why? Because the so-called white Anglo-Saxon Protestants, old stock Americans, or white, what they call British colonists has stole our birthright. They stole it. The rule. When a notification of birth registration is presented, except in lieu of public record of birth, it is properly certified by issuing agency or official in accordance with this rule, and it reflects the month, date, and year of birth. It completes dates of birth is not shown as a claimant to obtain preferred evidence. You see that? Blase, blase, blase. Let's go down to here. D, Bureau of Census form. Here we go. In 1924, the Bureau of Census began and issued the form notification of birth registration. This stopped in 1940, as you can see. 1940, what happened in the 1940s? Did anyone of y'all know what happened in 1940? No, I guess y'all don't. The Department of Census of the United States is governed under Title 13, Chapter 1, Section 1, which deals with definition of census, bureau, and respondents, which they define as corporations. Look it up. They're also subject to Title 5 of the United States codes, where it deals with the what they call the Privacy Act of 1974, with disclosure of private information. So they disclose the information to these different agencies of the state without your consent, by way of it not being signed by who? Your parents or you, because your parents are considered what? Ignorant, incompetent, by way of or have no knowledge of this social contract which the state created on behalf of who? Rome. So 1924 was also the same year that they made you American citizens, and they also did it with the natives, identified Indians, which you are those people. All right? It's right there. Here's also one more substantial proof. You see right here? Baptism, religious record of birth or baptism. That's not on the certificate of live birth, is it? No. Then each and everyone's got baptized, yes. Here it is. How to assist claimants in securing religious records. Where is it? Where is the securing of our civil status according to our religious relationship with our Creator? Where is it? It comes under the church. But they separated the church. What? An amendment of the Constitution of 1786. They cut it out. This is was not the instructions given by Queen Anne and to Viscount Cornbury. She told him that the executive, legislative, and judicial branch should be overlapping under the New Jersey Provincial Council, which was the head of the New Jersey Provincial Congress, which gave the states the right to create their own constitution in 1776 under a state church. Most of us don't believe that, do they? Do we? No, we don't. Let me show you more proof. Okay, let's go and put it in. I'm not going to, most of y'all are saying right now, you made that up. You made that up, Mr. Clifford Jefferson, the sovereign. Okay, I made it up. Let's show you how I made this. Let's see if I made this up. All right. Here's the records of the colonists who are the freeholders, i.e. the governors of each county. All right. Here's their records. Here's their record. Council of Proprietors of West Jersey, East Jersey. They were given a deed by who? Duke of York. Right? They were given the deed by Duke of York. Why was this deed given to him? For assisting the Duke of York. All right? It was given to John Carteret and George Berkeley. It's called the Quinton Party Deed. John Carteret and George Berkeley made other contacts with other people, which was unlawful. Unlawful. We're going to show you this was unlawful. And we're going to show you that all authority here in this particular territory is called what? Jersey. Now New Jersey is under the authority of the Crown. And successorship goes to his successors. We're going to prove it. All right? And we're going to show you what's going to happen to anyone that violates this right. These are the grounds for my lawsuit from them. All right? Council of Proprietors. Council of Proprietors of West Origin and History. Read before the Society, March 11, 1922 by Chester Craig. Register of the Council of Proprietors in West Division of New Jersey. Do you see that? Let me clear it up for you. First paragraph. The history of the Proprietors of Western Division of New Jersey is so interwoven with that of New Jersey that one can get a much better understanding of their origin by reviewing the early history of the colony. Did you hear that? So they're saying that the history of the Proprietors of a division of New Jersey is interwoven with that of New Jersey. It didn't become a New Jersey until the deed was given to John Carteret and George Berkeley by the Duke of York. Prior to that, it was under the authority of the Crown, state church. John Carteret and George Berkeley split it up to what was called East Jersey and West Jersey of the Proprietors. These are your so-called governors today, or your freeholders today. All right, this is who these people are. It says here, second paragraph, years ago, we won't go further. Years ago, we were taught that John Cabot, by the authority of Henry VIII, of England, and attempting to fund the northwestern passage to Indiana, discovered Labrador in 1497, the 14th month before Columbus discovered the continent. That his son Sebastian Cabot in 1498 discovered Newfoundland and the coastal as far south as Chesapeake Bay. That by virtue of the discoveries, the English acquired title to that portion of North America in which Jersey is situated. You hear this? That in 1664, the King Charles made a grant to his brother and Duke of York, afterwards to James II, of a tract extending from the Connecticut River to Delaware Bay. That the Duke of York in the same year made a grant to New Jersey to Carteret and Berkeley sold his undivided interest in New Jersey to John Fenwick, and a trust for Edward Beeling, an English Quaker, and his assigned. All of which, while true as far as it goes, does not give all the facts of the case. This ain't coming from my words. This is coming from their words. The Proprietors, the one who's running the government today. Because according to this record I'm reading, they surrendered their authority to the crown in 1702 to who? Queen Anne, under Queen's government. It's called Queen Anne's War. Read it, my brothers and sisters, if any of you brothers read. Okay, let's go down to 1, 2, 3, 4. Let's go ahead. You see this? On June 23rd and 24th, 1664, the Duke of York made a grant of New Jersey to Lord John Berkeley and Sir George Carteret, both of whom were tried as true cavaliers who had fought in the King's cause and were prominent figures in the account of Charles II. Okay? This is the Duke of York apparently did not know the value of the land. So when he granted the deed to John Carteret and George Berkeley, he didn't know the extent of land that he was given, that they themselves gave away, but they didn't have the authority to do so. But the Duke will correct his mistake. It says here, after several settlements, the next paragraph, had been made in northern and eastern parts of the tract granted to Carteret and Berkeley, war broke out between England and Holland and the Dutch squadron of 5 vessels appearing off New York. The fortress surrendered on July 30, 1673, and the Dutch again became master of New Jersey, and the officials of the various settlements took the oath of allegiance to the Dutch crown. You hear that? They took allegiance to the Dutch crown. So let's get to the meat of this. All right, let me go a little further. All right. The Dutch crown. It says, but by reason of the conquest by the Dutch, the English government in New York and New Jersey came to an end, and the grant to Carteret and Berkeley was, according to the principles of English law, rendered what? Void. Did you hear that? Rendered void. It's right there. Rendered void. So that means that all so-called legislators that operate within this county, that sits within the state, New Jersey was part of, or Memphis County was part of what they call East Provinces. East Province was under the authority of the New Jersey Provincial Council, under the authority of the New Jersey Provincial Congress. Right? So therefore, anybody who sits in the seats of a legislator in the county, authorities is automatically be surrendered under the crown by way of the deed given to John Carteret and George Berkeley is rendered void. It's rendered void. This is in their own records. So how the heck is the so-called shareholders or freeholders holding clear estate and being elected to these offices if they have no authority according to their own records? This is your own proof. All right? So now let's show you where they did wrong. Let's see how they got bold. All right, let's go ahead. I'm just going to stop at this point. You see that? The trustees instituted an investigation on the transaction between the Fenwick and Edward Beiling. That's his name, Edward Beiling. And found that the former had only 1/10 interest in New Jersey lands, while their principal was in fact the owner of the 9/10 of the conveyance. Fenwick at first resisted this award, but in 1682 relinquished his claim to any further right in the state and the moiety of New Jersey. This trustee handled the matter in a very able manner. They divided Beiling's interest into 100 shares or properties, and from other sales of a small portion of the share received sufficient to pay the creditors in full. That was a lie. They sold it to what they call green acres. We're going to prove it. All right? All right. It says here, the proprietors under authority of John Carteret and George Berkeley, Edward Beiling and Fenwick gave it back. He had no part of this. But it says that they framed a set of laws and plan of colonization under date March 3rd, 1676, entitled The Succession and Agreement of the Proprietors. This is the Constitution for them. Okay? 1676 concession agreement, a contract, agreement between those electives, freeholders, i.e. governors and so on and so forth, which George Washington and all them descended down from these so-called proprietors. to inhabit the province of West New Jersey in America. Comprising 44 chapters, the last 32 chapters being the Charter of the Fundamental Laws of West Jersey agreed upon and signed by 150 persons. Did you hear that? Did you hear that? Paragraph, it says, up to the time, the entire province had been held in common by Carteret and Berkeley, and later by Carteret and Bingley. All right? But Berkeley sold his to Bingley. Berkeley sold his to Bingley. John Carteret kept his. He dies, though, we're going to see. Once the king sends one of the advisors to check things out. When, however, new interests appeared, it became necessary to definitely establish exact shares of two principals. On July 1st, 1676, William Penn, Gone, Lauren, Nicholas Lucas, and Edward Bingley executed a deed with Carteret known as the Quinton Party Deed, in which the territory was divided in two parts. East Jersey being taken by Carteret and West Jersey by Edward Bingley and his trustees. The trustees showed their foresight. For a while, the land covered the Duke's second grant was divided as nearly equally as possibly. The deed was drawn in such a manner that Carteret also conveyed a trustee. One second. Carteret also conveyed to the trustees all his interest in the deed, conveyed all the interest in that part of New Jersey which was south of the southern boundary of the second grant. Let's go a little further. All right, let's show you where the king gets involved. Let's go ahead. The properties then sent 5 commissioners to New Jersey to represent them in selling land and laying out towns. Their instructions being dated the 6th month of 18th, the 6th month, the 18th of 1676, so that it will be seen that no attempt was made at the colonization until after the Duke's second grant was obtained, i.e. Ratified. Before going to West Jersey, the commissioners thought it best to call on the Duke representatives, Governor Andros in New York, who would not concede that the proprietors had obtained the rights of government under the Duke's second grant to Carteret, and would not allow the commissioners to proceed until after they had consented to take out warrants as his subordinates. You hear that? As the king's subordinates. So King George III had these so-called colonists as subjects. This is Governor Andros. This goes back to the so-called native burghers. Andros goes back to family. Look at the family crest of Andros. It comes from England. Look it up. Governor Andros is claiming the right of government, also claimed the right to levy a 5%. Now they're being taxed for what they did on all inputs to West Jersey. To this, the people of West Jersey objected strenuously. Oh, now the colonists get mad. So George Carteret, having died, his grandson and heir, Philip Carteret, so means nobody is excused. You have no excuse for what you did, because if you being the heir, receiving it by unlawful deeds and titles to our vast estate would be a violation of the Treaty of Paris of 1784, ratified. But it didn't have a right amount of delegates, which you clearly stated here. All right, it says here, the people of West Jersey objected strenuously, so George Carteret, having died, the grandson and heir of Philip Carteret, and assuming the governorship of East Jersey, watch, keep going blank on me. Sorry. Governor of East Jersey, where is it at? Objected strenuously, so George Carteret, having died, his grandson and heir Philip Carteret, and assuming the governorship of East Jersey, was arrested by Andros. What? He got locked up. Penn laid the matter of the properties before the Duke of York in an able manner, stating that it was represented by Berkeley. See, now they putting the stuff back on Berkeley? They both are responsible for something that was unlawfully did by Berkeley due to the fact that he took something as a right, which was not a right. It was a gift. And Berkeley goes on to say that they had the right of government, and that if Billings would not have purchased they would not have purchased a loan from Berkeley. Let me read it from the script. It says that Penn laid the matters of properties before the Duke in an able manner, stating that it was represented by Billings by Berkeley that they had the right of government, and that Billings would not have purchased the land, purchased had he known that the Duke had reserved the right. So that means that Bangland would have never purchased the land from Berkeley if he would have known that the Duke ordered for him not to sell the land because it was under the Duke's jurisdiction, which was the case. So there you have it right there. Proof from the Council of Profiteers. All right. I got one more evidence to support my complaint in lieu of this Bible lawsuit on behalf of my people. All right. There's one more proof. Here we go. This is their records. You hear that? Using the records of East and West Jersey profiteers. Look at what they said. Okay, here we go. Who are the profiteers? You see that? Who were and who are the profiteers? Based on the joint rights granted by the Duke of York to Sir George Carteret and John Lord Berkeley, New Jersey became a proprietary colony with Eastern and Western divisions. East Jersey developed, was tied to New York, New England, and former Dutch colonies of New Netherland. The settlement of West Jersey on the Delaware River was initially a Quaker venture and was associated with William Penn and others involved in the colonization of Pennsylvania. That's under the Clinton Party deed I was speaking about. The succession to Carteret and Berkeley interest in New Jersey essentially involved into the corporate East and West Jersey profiteers respectively. They were the first British landowners of New Jersey and governed the province during the first 4 decades of British colonization. In 1702, after the profiteers in East Jersey and West Jersey had surrendered their government authority several times, Queen Anne established New Jersey as a unified colony. Did you hear that? Unified colony. So what are we going by today? What are we going by today? It says in the next paragraph, in 1998, the East Jersey profiteers reportedly New Jersey oldest corporation dissolved and sold their rights to the unappropriated land to the state Green Acres program. You hear that? Gave their land up. So why are the profiteers still operating today if they gave up their land to who? Green Acres, which is also an agency of the state, governed under the state of New Jersey. Proof is right there. All right. And so it said, and why do you care? Why do we care? This is what they're telling us why should we care. It says here, second paragraph. Since the recording of land conveyance, it has always been voluntary. And since this function was not fully available in the county seat until 1785, for deeds in 1766, for mortgages, proprietary surveys, records are vital for documenting colonial land owning families. This is what we call United States Census, United States Department of Census Bureau. All right, this is what's needed for documenting colonial land owning families. Throughout the records are buried innumerable genealogical facts. You hear that? Genealogical facts and connections. Since very little has been published in terms of abstract or transcripts of the profiteers' books, serious research requires using the original documents on microfilm. This is where the in 1940 they were transferred under Section 5 of the United States Code to what they call microfilm under the Privacy Act of 1974, in lieu of personal identifiable information on statistics of citizens. All right, it's governed under the, as well as Title 13 of the United States Code, Chapter 1, Section 1. All right, look at it, or do the knowledge. It says, genealogical documents aside a basic knowledge of East and West Jersey profiteers and the partition line between the two provinces will aid any genealogist researching colonial New Jersey families. You hear that? So if you're saying that you have a right here in what we call North America as being the true heir or native to this land, it comes to your family descent name. It comes to your family descent name. Without it, you have nothing. You have nothing. So with that, give me 1 second. With that, I'm going to read one more thing as I come to my closing. It says here. Where's it at? Give me 1 second. Yes, it's right here. The dispute related to land rights. The dispute related to land rights inquiring plagued East Jersey throughout the proprietary period. 1 second. Let's see. Second paragraph. Dispute related to land rights inquiring plagued the East Jersey throughout the proprietary period beyond the 1702 surrender of government rights. The controversy over lots granted by Elizabethtown Associates culminating in 1745 bill in Chancery. In its answers, it is a reminder that even after the East Jersey properties were no longer a governmental authority, they were still at odds with a proportion of the settlers to the end of the colonial time. In West Jersey, where shares were divided into smaller fractions, there were greater opportunities for persons other than the extremely wealthy to hold stock in its land. Acquirements were not required in much of West Jersey due to the wide distribution of land rights and the resulting competition for settlers. While West Jersey governors Edward Beiling and Daniel Coates often acted as counsels with the charting concession agreements which Beiling himself had written, the democratic ideas found in these documents had a positive influence on the relationship between settlers and the proprietors. And with that, I end my lesson on regards to we are the true descendants of the native, what we call New Jersey. All right, we're the true natives, but only as Anglo-Saxon burghers. And here's the proof, authenticated and substantiated by who? The proprietors. And with that, I say peace and love.